Hello and welcome to this Primary Care Direct webinar. My name is Alistair Kernohan and I'm an associate at Capsticks. This is a quick presentation about some employment law issues to consider as we start to come out of lockdown and begin returning to work. I won't cover everything, but hopefully you'll find it useful as a starting point. Capsticks is part of a consortium of organisations that make up Primary Care Direct. We're a law firm that specialises in health and social care and act for GP practices on a wide range of legal issues. My specialism and the focus of this webinar is employment law, but should you have the need for any legal advice regarding your practice or PCN, please get in touch either directly or via Primary Care Direct. Both contact details are available at the end of the presentation. Here are just a few other of Primary Care Direct's associate members before we get on to the main presentation. So this is what we're going to cover today. Health and safety issues, managing concerns, protecting the vulnerable, and a summary at the end of what you can do, along with some further reading and useful resources. So section 1, we'll just talk about some health and safety issues. As an employer, you have to do all that you reasonably can to set up a safe system of work and ensure that it's implemented. This is a statutory duty, which means it's enshrined in legislation, such as the Health and Safety at Work Act. It's also a common law duty, which has evolved through decisions made in the courts. It's important to be aware of this, as a breach of the statutory duty can be a criminal offence, and it can also be relied upon in any civil claims that might be brought against you as the employer. The starting point to ensure you're doing everything you reasonably can is to follow the government guidance. However, simply following the guidance does not necessarily mean you've discharged your statutory or common law duties. So how do we create a safe place of work? There are some practical points outlined here on the slide to help you. Key points to take away: firstly, assess the risk. You're required to record that in writing if you've got more than 5 employees and publish it if you've got more than 50. Secondly, set up a safe system based on that risk assessment that you've undertaken. Be slow and take your time. Assess risks carefully. Have a test run with a few employees if you need to identify any pinch points or issues that might not be apparent on paper. Also, there are obligations on employers to consult with employees about health and safety arrangements at work and the effectiveness of measures that to be put in place. This is required under legislation in the Health and Safety at Work Act, but it's also a good employment practice. Third key point, make sure the system is followed. It's important to remember that you're responsible as the employer, not just for implementing a safe system of work for the employees, but also making sure that it's followed. So you need to instruct, manage, and incentivise compliance. In short, instructing employees won't be enough. You need to ensure that those instructions are carried out. And if employees don't follow those instructions, you may be in a situation where you need to consider taking disciplinary action, because if you don't, then you could be liable for anything that arises out of that. So the next section, managing those concerns. So the obvious question is, can employers force people to come back to work? If they don't want to, the answer is no. But it doesn't mean that employees are entitled to stay at home on full pay or keep their jobs. So, what can be done? Well, the answer to that is each case will need to be considered on its own facts, and it will depend upon why a particular employee is refusing or unable to come into work. If a refusal to come back to work is based on health and safety concerns, then the Employment Rights Act is likely to be relevant. The relevant sections are summarised here on the slide as sections 44 and section 100 of the Employment Rights Act, which says employees have the right not to be subject to a detriment or be dismissed because of anything they've done, proposed to do to protect themselves or others, including a refusal to work, return to work or leave work, in circumstances of danger, which the employee reasonably believed to be serious or imminent. Now, this is based on the reasonable belief of the employee. So if the employee has reasonable belief, then they're protected from day one of their employment. And if they're successful in any claims under these sections of the Employment Rights Act, then it can lead to uncapped compensation. What amounts to circumstances of danger, as referred to under the legislation, is an objective test. It's likely to be widely interpreted, and it's likely to be satisfied in most cases, especially if an employee is not complying with health and safety obligations. But it's not automatic, and each case will need to be considered on its own facts. In terms of an employee's reasonable belief in imminent danger, well, that's a subjective test, and again, it's likely to be broadly interpreted. And it's the individual employee's interpretation of the situation that matters when that's being done. And it would probably be hard to argue that the risk of COVID-19 would not be considered serious or imminent. You could have a situation where both the employer and the employee are acting reasonably in terms of the law. So where does the balance lie? And the answer to that will be, as I said before, a question of fact to be looked at on each particular case. Another point to mention in relation to these particular parts of the legislation is that it refers to the employee's actions being to protect not only themselves, but also others. Now, potentially those others don't have to be other people in the workplace. It may be broad enough to cover vulnerable people the employee lives with, for example. Though this definition is largely untested in the courts, so there's some uncertainty around that. As it says on the slide there, it's not that simple. As I mentioned, both sections 44 and 100 of the Employment Rights Act are underused, so there isn't a significant amount of case law or guidance to rely upon in these circumstances and at these particular times. Although causation is likely to be a tricky issue in any case, which means establishing whether the act done by the employer was actually in response to the protected conduct of the employee. For instance, is the decision not to pay an employee because of their absence from work, or the reason for their absence from work? Now, there's a fine line between the two, and it's likely to be subject to a number of cases and litigation in the coming months and years. Some other rights to consider are outlined on the slide there. Obviously, whistleblowing is a potential factor where an employee raises concerns about health and safety. They're likely to be protected as a whistleblower, and that gives them rights and protections against detriments and dismissal. So you need to be alive to that potential issue. Withholding pay might be something that you would consider when an employee doesn't or refuses to return to work. Again, you need to be mindful of the risk that could lead to an unlawful deduction from wages claim. Alternatively, an employee might argue that such conduct amounts to a breach of trust and confidence, which leads them to resign and claim constructive dismissal as well. So that's another issue to bear in mind when you're dealing with these particular tricky issues. And it highlights the importance of consultation and being mindful of the specific duties owed to particular groups of workers, such as disabled workers and pregnant women, who obviously have other protections under the Equality Act that you need to be aware of. So what can employers do? Employers can dismiss employees or withhold pay if they refuse to come to work because of COVID-19. However, if employees reasonably believe that the threat to their health and safety or the health and safety of others is serious or imminent, and cannot reasonably be controlled by the measures that you as an employer try to put in place or intend to put in place, then any dismissal in those circumstances would be automatically unfair. So, as with any other kind of circumstance, dismissal is obviously the last resort, as it involves a high level of risk and potential claims against the employer. As I said there on the slide, it's important to explore all other options before going down the dismissal route. Things like working from home, special leave, furlough where possible, but that's tricky in the public sector, health and safety suspensions, or other options such as temporary changes to the roles and hours that people work, unpaid leave, using holiday and that kind of thing. But whatever you decide to do, it's important to make sure that that's all fully documented so that it provides you with a paper trail in the event of a future dispute. For example, a claim that might be brought, you've then got something to refer to justify the decisions that you've taken. Just moving on to just a couple of slides about contingency planning. As I mentioned, try and identify any pinch points and consult with staff and staff representatives to try and agree a way forward. Doing things by consent and agreement is always the best way to proceed and the way of least risk as well. Look at other options within the existing workforce. Can people work extra hours? Can you redeploy staff? Is it possible to implement any workforce sharing arrangements with other practices, for example, recruitment, and see whether any staff may want to return? They're all things that you can look at as an alternative when you're trying to manage a situation where you have some employees who don't want to return at the current time. Looking at annual leave as another alternative, just to make it clear that holiday can be cancelled by the employer as long as that's done with notice. There are also a greater amount of carryover now in annual leave, so 20 days can be carried over for the next 2 holiday years, which again might come in handy when you're trying to manage the current situation. You can direct an employer when holiday should be taken if they're still working. For those who are ill or on sick leave, you need to be a bit more careful. You can request a leave be taken, but it can't be forced. And the situation is a bit more complex when you're dealing with those who are shielding or self-isolating and unable to work. As highlighted on the slide there, any action you take could or runs the risk of potential discrimination claims if not handled correctly. Just a quick mention about testing. It'd be a reasonable management instruction if testing is available to require employees to be tested. If employees refuse to be tested and attend work, it can be treated as unauthorised absence and pay can be withheld. Although, as I mentioned before, there's always a risk when you withhold pay that an employee might try and bring a claim of unlawful deductions of wages. And I've just mentioned data protection there as well. Staff should be encouraged, obviously, to disclose test results by consent. But if that is refused, then as an employee, you can rely on health and safety obligations, as the non-disclosure of a positive test clearly puts patients and staff at risk. So it may not always be necessary to get explicit consent from the employee. But as I mentioned earlier, doing things by consent and with agreement is always the best way forward if possible. So moving on to protecting the vulnerable. Just outlining on this slide what we mean by the clinically extremely vulnerable employees, which is in line with the HSE guidance issued in May this year. So those are at high risk from C19 and must shield. NHS employees said those extremely vulnerable employees are entitled to receive full pay through the provision of C19 special leave. Can't require or agree that they return to work given their particular circumstances, as any return to work would be in breach of health and safety obligations. It's also important to point out that you can't agree to opt out of health and safety obligations or to sign away any rights to a personal injury claim, for example, through any kind of disclaimer. So any agreement or disclaimer to that effect would be worthless. It wouldn't be worth the paper it's written on, and it would expose the employer to risk if you were to try and go down that route. The next tier down, if you like, the clinical vulnerable employees, they're at moderate risk from C19. This includes pregnant women. There's no requirement for those shields, so they can return to work. But any return to work for a vulnerable employee must be individually risk assessed to ensure that all health and safety and Equality Act obligations are met. So employees who are living with those who are extremely vulnerable or vulnerable, there's no requirement for those employees to also shield if they're living with an extremely vulnerable person. For those employees in that situation who refuse to return to work, there still are some potential issues to be aware of. Under the Equality Act, there are something known as an associative disability discrimination, which means that an employee who isn't themselves disabled but lives with a disabled person is potentially protected against direct discrimination, harassment and victimisation under the Equality Act. So again, it's just something to be aware of, and that kind of issue should come out in dialogue with the individual as well when reasons as to why they're refusing to return to work are explored. So there is that one. Obviously, there's the potential issues under Section 44 and Section 100 we talked about. Again, the unlawful deductions from wages claim as a potential if that's something that was threatened for an employee in this situation, as well as unfair dismissal claims if you went down the dismissal route. There's also the whistleblowing claim and protection that an employee would have potentially, which again is something you should be live to. So what now? These are obviously uncertain times. There aren't any precedents. None of this has happened before. None of the law was drafted with these particular circumstances and the current pandemic in mind. So it is difficult to navigate. It will, just because these things take time to work their way through the courts. It'll be some time before we have any real guidance through case law as to how some of the trickier areas should be managed. So we don't have the benefit of that kind of guidance. So as I mentioned earlier, where possible, the best way and the least riskiest way of proceeding is by agreement, to try and minimise the risk of any disputes going forward. And key message there, just obviously be kind, open and supportive with staff is obviously the best way to proceed and again mitigate any potential risks there might be. Just finally moving on just to some useful resources that you might want to look at. If you go to our Capsticks website, there's a section there dedicated to primary care, which does contain some COVID-19 specific FAQs. There's also guidance available outlined on this slide from his employers, government guidance and ACAS guidance as well. Well, I hope you find that session quite useful. I appreciate it's brief, but as I say, if there are any other questions that you have which aren't answered on our website or through the other guidance, please do get in touch. My details are on the slide there. I believe the slides will be made available via Primary Care Direct in due course. But in the meantime, please get in touch if you have any queries, and thank you for your time.